Hi, I'm Jen, a Senior Associate in our Corporate Services team, and today I'm going to be talking to you about Articles of Association and Shareholders Agreement and the importance of having up-to-date documents in place. So constitutional documents are essentially articles of association of companies. So every UK private company needs to have some articles of association, and then optionally a shareholders agreement that regulates the relationship between the shareholders and the company. Articles of association are a bit like a user manual. It's what regulates how the directors need to operate and what the rules are around shareholders meetings and directors meetings. A shareholders agreement is really important if you want to include some restrictions on perhaps what the board can do. So give the shareholders some power to influence what the board's decisions are, or to take a consent matter, for example, if it's a big ticket item or something that's quite important to the shareholders to have a say in. So again, having a shareholders agreement in place can be really important to particularly shareholders. Articles of association of a company should be reviewed regularly. A company's articles of incorporation are no longer relevant to how the company is operating now. For example, you would want to make sure that those articles of association have restrictions on the transfer of shares, so that a shareholder can't decide one day to transfer their shares to a family member or a neighbour or someone inappropriate. You'd want to be able to control the circumstances in which those shares can be transferred, and perhaps consider what would happen if that shareholder went into some sort of insolvency or bankruptcy process, or perhaps that shareholder was to die. What happens to those shares? And the Articles of Association is a good way in which you can control that. So it's important the articles are up to date and they do use the most current model articles, which is the 2006 model articles. The other thing to consider is that if you have the 1985 model articles, the chances are that the memorandum of the objects in the company's memorandum of association still apply, and they don't need to anymore. So by adopting new articles, you can remove those objects, the restrictions on what that company can do, the powers it has, and it just frees up the company to develop the business in the way it wants to. The Articles of Association can also set out how the directors are appointed. It can also set out the maximum number of directors that can be appointed at any time, and also how, in what circumstances, they may no longer be a director. It's really important for the Articles of Association to set out the rights that attach to a company's share capital, but also the different types of classes to be allotted a certain class of share. So it's really important in the articles that that is very, very clearly defined. It's very important to allow in the Articles of Association the ability for a third party to acquire the share capital of the company in the future. So a shareholders agreement is a private document, so it doesn't go onto Companies House, it's not shared publicly, and it is an agreement that's entered into by the shareholders of the company and the company itself. So things you might want to put in the articles, you can put in the shareholders agreement. The areas that are often covered in the shareholders agreement are things like what rights do shareholders have to be a check on the board. The shareholders agreement can also set out, does the company need to have a business plan, and what's the business plan going to include? It'll also set out what information rights shareholders might have. Articles of Association can obviously have quite general provisions around dividends, but the shareholders agreement could actually have a bespoke dividend policy. The other way in which it's really important, or which is very useful for a shareholders agreement to include, are what we call restrictive covenants. And restrictive covenants are obligations on the shareholders to not compete with the company. So a shareholder might not be running the business day to day, but the company wouldn't want to have a shareholder that actually does something very similar to the company down the road that's actually in direct competition. It's very common in a shareholders agreement to include a confidentiality clause. Shareholders can often obtain quite confidential information about the company, perhaps the management accounts, business plan information, even the draft annual accounts can be confidential. So there's a lot of information that they will inquire, and it's really important for the company to protect its business interests, and a lot of that is about keeping confidential information confidential. The shareholders agreement is a perfect vehicle for making sure those shareholders understand that they have to do that. And I hope you found this video helpful. If you need any more information about shareholders agreement and article, or would just like to chat, please get in touch with the corporate services team here at Muckle LLP.